Right now, the very foundation of the United States government is fracturing. A constitutional stress test unlike anything we've seen in our lifetimes. Welcome to this explainer. Today, we are looking at the raw facts, the source material drawn directly from a recent, highly detailed Frontline documentary. We're unpacking how executive power is being aggressively unleashed, and more importantly, how this fundamentally alters the traditional rule of law in America.
To truly understand the sheer scale of these legal shifts, we've broken this explainer down into 6 pillars. We'll cover the unitary executive theory, the Supreme Court catalyst, reshaping the Justice Department, dismantling the federal bureaucracy, pressuring the legal opposition, and finally, the ultimate judicial test.
Part 1. The Unitary Executive Theory. Let's track the evolution of presidential power. It's a dramatic shift. In the 1970s, following the fallout of Watergate, tight constraints and independent watchdogs were strapped onto the presidency. But then came 2001. After 9/11, there was a massive, sudden push for a stronger, faster executive branch. National security demanded it. And that exact trajectory brings us to 2024, culminating in a historic Supreme Court decision that expands this power further than ever before.
To understand what's happening, you have to understand the legal philosophy driving it. It's called the Unitary Executive Theory. At its core, this theory interprets the Constitution as giving the president complete, unconstrained control over the entire executive branch. Advocates of this, like legal scholar John Yoo, argue that a president simply shouldn't be hampered by independent agencies or congressional red tape. It is the absolute centralization of power, one single person holding all executive authority.
Which brings us to Part 2, the Supreme Court catalyst.
In the landmark ruling of Trump v. United States, Chief Justice John Roberts declared something that shook the legal foundation. The president may not be prosecuted for exercising his core constitutional powers. The source material points to this exact moment as the catalyst, a ruling that granted a sweeping immunity, fueling the very actions we are about to explore.
And this ruling split the country in half. Supporters argue this immunity is absolutely essential. It allows a president to act decisively without being paralyzed by the fear of future lawsuits or political prosecutions. But the critics? They issue a dark warning. They argue this removes the exact constraints put in place after Watergate, effectively placing the President of the United States entirely above the law.
Part 3. Reshaping the Justice Department.
We are witnessing the sudden collapse of a 50-year norm. Historically, the post-Watergate consensus was that the Department of Justice must operate with strict independence, a firewall against political weaponization. But the unitary executive view, it completely rejects that firewall. The new administration's stated position is that the DOJ works directly for the president. It is an instrument to carry out his specific agenda, whether that means prosecuting political opponents or dismissing cases against allies.
And this wasn't just theory, it was put into action immediately. Take the corruption case against New York Mayor Eric Adams. The documentary details how the administration actively moved to drop federal charges against him. The acting Deputy Attorney General Emil Bove explicitly cited that the pending prosecution restricted the mayor's ability to help with the president's mass deportation agenda, a direct trade-off.
But that decision sent shockwaves through the department. It led directly to the resignation of several career prosecutors, including conservative attorney Danielle Sassoon. Her words were sharp. She stated she could not agree to seek a dismissal driven by improper considerations. Career prosecutors see these moves as politically motivated quid pro quos. The administration, however, maintains they have the absolute constitutional authority to direct the DOJ exactly as they see fit. Part 4. Dismantling the federal bureaucracy. 98%. Think about that number. In a blinding display of executive authority, the administration targeted USAID, the agency responsible for foreign aid. Almost overnight, they cut its workforce of 14,000 employees down by an astonishing 98%. Career officials were locked out of their systems, virtually no warning, gone.
But they didn't stop there. Simultaneously, 17 independent inspectors general were purged. Remember that post-Watergate timeline? These inspectors general were the very watchdogs created by Congress to oversee government spending, to investigate corruption. The administration removed them instantly, bypassing the legally required 30-day notice to Congress.
Once again, the source material presents 2 entirely different realities. The administration's perspective? This is a long overdue dismantling of a bloated, wasteful bureaucracy, a harsh but necessary move to restore true efficiency.
The critics' perspective? This is a deliberate, systematic destruction of independent oversight, a move to punish dissent and consolidate all federal power directly inside the Oval Office.
Part 5. Pressuring the legal opposition.
Using a rapid series of executive orders, the administration aggressively targeted major corporate law firms. The reason? These firms had previously represented political opponents or dared to file lawsuits against the administration's policies. The retaliation was swift. The executive branch revoked their security clearances, denied them physical entrance to federal buildings, and abruptly canceled their highly lucrative government contracts.
And the pressure worked. Feeling the crushing, immense weight of the federal government, many of these powerful firms folded. To get back in the administration's good graces, they struck unprecedented deals, agreeing to provide nearly $1 billion in free legal services to causes supported by the administration. Critics call it mob-style intimidation. The administration calls it playing hardball to break anti-democratic forces.
Part 6. The ultimate judicial test.
The battleground for this final clash centers on immigration. The administration initiated the rapid deportation of alleged gang members to a notorious high-security prison in El Salvador. But civil rights groups sounded the alarm. They argued this sweep was grabbing innocent people, entirely bypassing standard judicial review and due process. The trap was set for an immediate legal showdown.
And the constitutional crisis arrived. Federal Judge Jeb Boasberg issued an emergency restraining order. He demanded the flights be halted to allow for basic due process hearings. The executive branch's response? They simply ignored the court order. Let that sink in. For the first time in modern history, the executive branch blatantly refused to yield to a federal judge. They claimed absolute constitutional authority, labeling the judge a rogue actor trying to sabotage a military operation.
The administration escalated fast. They began publicly attacking the judges themselves, even demanding their impeachment. The pressure grew so intense that the Chief Justice of the Supreme Court, John Roberts, was forced to step out of the shadows. He issued a rare, direct public rebuke to defend the judiciary's independence, reminding the country that impeachment is not an appropriate response to disagreement concerning a judicial decision.
Which brings us to the edge of the cliff, the most critical question of this entire explainer. As these high-stakes cases race toward the Supreme Court, what happens to the rule of law if the executive branch simply decides that the ultimate referee, the judiciary, can be completely ignored? How our constitutional system navigates this exact stress test will define the American government for generations. Thank you for joining me. And whatever happens next, keep questioning what you see.